So today we have our fair housing program, particularly focused on evictions and what are your legal rights when it comes to evictions. And joining us today, great that you're joining us, is we have Rashida Rattray from the Connecticut Fair Housing Center. And then we also have Mary Conklin, who will be offering some legal services, and she is from the Connecticut Legal Services Agency with the city. So I'm so happy to welcome you tonight, and you can get started when you're ready.
Awesome sauce. Thank you guys for having us this evening. I'm Rashida Rattray, the Education and Outreach Coordinator over at the Connecticut Fair Housing Center. And what I want to start off doing is giving you guys a little bit of background with regards to fair housing and the Fair Housing Act and kind of how this all ties into having rights when you're going through an eviction process. So this session is being recorded. You are going to have the ability to view the session, whenever time you can, but just be mindful that some of the information, if you view it maybe a month or two from now, some of the information may be a little bit outdated and you might need to just update yourself with regards to that. So keep that in mind. Also, for our friends who are joining us virtually, please know that you have the option of posting your questions in the chat box. And for those who are joining physically, you do have the option of letting LaShawn know that you have a question and being able to ask it that way. I am having a slight technical difficulty with my PowerPoint because I'm trying to start it from the beginning and make it full screen. And it doesn't want to do that for me now. So if you can give me just 1 second. Zoom, right? It works perfectly when you are practicing, but then when you are trying to get it up after your practice, it sometimes has some discrepancies. And while I try to get this up and going, if you guys have any questions that you just have off the top of your head before you got here, please do let me know. You could type those into the chat box. Mary, if you wanted to jump in and give a brief introduction about yourself and your services while I try to figure this out, you are more than welcome.
I can do that, although that's also a little bit of my PowerPoint, so I'll skip it later. So I'm Mary Conklin. I'm the managing attorney for all the housing attorneys working for Connecticut Legal Services. Connecticut Legal Services is a program that provides representation and advice in eviction matters. We're one of several programs throughout the state that does eviction work. The other primary programs are Greater Hartford Legal Services, New Haven Legal Services, and then there's a veterans organization that also provides legal services. The Fair Housing Center does a lot of great housing work, particularly in the area of fair housing, but not so much in the area of evictions, at least direct representation. They do advice and other good work in that area. So I'm here today because our program, which I kind of consider a balance of state because it doesn't have New Haven and Hartford in it, we do cover Stamford. So we would be the legal aid agency that tenants from Stamford would go to if they were seeking assistance. So
What I'm going to do
I
is
just wanted to let you know that. Okay,
Thank
so I
you
can
guys so
move up
much.
there.
I will pop in again. I'm going to stop my share and restart my share, and hopefully that works. Please forgive us for our technical difficulties at this time. Well, mostly me for my technical difficulties. But what I can do is just start this introduction while we're trying to get this back up and running. So I work for the Connecticut Fair Housing Center, which is a statewide private civil rights nonprofit. And our goal here at the Connecticut Fair Housing Center is to ensure that all people across the state of Connecticut have equal access to housing opportunities that are ideally free from housing discrimination. We recognize that housing discrimination is an intersectional problem, right? It's not just a single lane or a single thought or a single act that can sometimes, lead to housing discrimination. We all live in separate silos. I know there's a quote that I like to reference, and I forget who the author is, but the quote basically says, "We are not single human beings, right? We're not just one thing when you look at us. We are multifaceted. We have intersectionalities within ourselves and within the lives that we live. So, of course, some of these issues that we come up against when we're trying to address them, they may be multi-faceted issues. So we deal with the intersection of poverty and housing discrimination, and we also try to help individuals who have been hit hardest by the nation's ongoing foreclosure crisis. Here we go. We got our presentation up. Hopefully you guys are able to see that. So I just went over what our mission is in just a while ago. So we're going to pop on to the next slide. So a little bit about fair housing, right? Fair housing is the right to choose housing free from unlawful discrimination. You should be able to live wherever you can afford to live and not have to worry about being treated differently because of things such as your race or whether or not you have children or whether or not you have a disability. We have federal and state fair housing laws that were put into place to protect people from discrimination in all housing transactions, such as rentals, sales, lending, accessing shelter, and even insurance. But it's not limited to just that list. The Fair Housing Act was born from decades of discrimination, segregation, and disinvestment, and is made manifest through the Fair Housing Act of 1968, which was passed in April of 1968. And I'll give you a little bit more details on the passage of the Fair Housing Act in a couple of slides. The Fair Housing Act prohibits discrimination in housing and housing-related services based on your membership in a protected class. And some of these terms may be a little bit unclear now, but we're going to get into, describing what discrimination means. How do we define it at the Fair Housing Center and under the Fair Housing Act? And what is a protected class? But I just always want to give a little background on what fair housing is not. So we are not a fair rent commission. A lot of times we'll get people that will ask us, well, what are we doing to lower the rents or to report landlords who are charging unjust rents? Unfortunately, we don't handle or work in that service area. A fair rent commission would be instrumental in that area. Fair Rent Commission being a committee of people who are put together to oversee rental increases and to make sure that landlords are not charging outrageously high or unjust rent. If they are, you're able to bring that to the Fair Rent Commission. They're able to investigate that and take whatever necessary action. Also, Fair Rent Commissions can handle unhealthy conditions within a unit or within an apartment. They're able to work in tandem with the city or a town's health department to regulate that. We are not a housing provider or a housing authority. Unfortunately, we do not have any housing that we can point people to. We do not own any housing ourselves other than the ones that we live in. So we're not a housing provider. We often get mistaken for Connecticut Housing Finance Authority because the names and the acronyms are a little bit similar. We are not them. That is a separate agency that operates in separate silos. They more focus on, helping first-time home buyers become educated, helping people who are going through foreclosure connect with housing counseling agencies, and, facilitating housing-related education. And they do have a program that is grant funded for individuals that are able to get down payment assistance when they're looking for buying their first home. But we are not them, unfortunately. We also are not a mediator between landlord and tenants disputes that do not involve discrimination. Now, for example, let's say you're having a conditions issue where you are, grappling with your landlord with regards to something like rodents or, something as if they need to fix lighting or fix the temperature in your home. Unfortunately, we wouldn't get into a landlord and tenant dispute unless it involved discrimination. So for example, let's say you had a rodent problem, but you were the only African American family that were living in that unit, and your neighbors who happened to be, of a different race also had that problem. That problem was fixed for your neighbors, but then you're having some back and forth and contention between your landlord with fixing that issue for yourself. That is something that we may be able to investigate as a discrimination complaint. Lastly, we are not legislators, right? We are not there writing, proposing, or making new laws. We are just an agency that advocates for more equitable policy. And we're going to get into what we actually do in a couple of slides. In this slide. Um, so we offer foreclosure prevention and intervention services for individuals who may be at risk of foreclosure or going through the foreclosure process. Just a quick little breakdown. When an individual buys a home and they sign a loan document, you sign that loan document saying that you are putting up your home as collateral if you are unable to make your financial obligations to that loan. So if you are, unable to pay that loan, there is a period of time where you are unable to pay it fully or unable to pay it at all. And then after that period of time, the foreclosure process will start, in which the bank will try to take back the home as collateral for you not being able to fulfill that promise under the loan. So we offer, legal staff will sit with individuals who are going through the foreclosure process, answer those complex legal questions that you may have that you can't ask your regular community service agency, such as your neighborhood housing services or, your new opportunities. They're not going to be able to answer those legal questions for you, but we're able to do that. So you can sign up for our advice panels, and then they're able to help you. Our legal staff is able to help you through that process. The Education and Outreach Initiative is spearheaded by me, in which my goal is to make sure that anyone within the state of Connecticut that has anything remotely to do with housing, whether you are living in a house, whether you are providing housing-related services, they know who we are. They know that people have rights under the Fair Housing Act, and they know where to go when those rights are being violated. Here is where we are instrumental when it comes to legislature. We are advocates for equitable policy to take the place of some of the discriminatory policy that we know has a negative effect on the housing arena that we're dealing with today. Our newest venture of work is tenant empowerment, in which we are trying to make sure that tenants know that they do have rights under the eviction process. Sometimes it's a little bit complicated. Eviction is when, it's basically, if you look at foreclosure as the bank taking back the home when you're unable to fulfill that payment, eviction, even though it's a little bit more complicated, I'm going to let Mary take the reins on that one. But eviction relates to individuals who are renting their property. We know that the eviction process can often have people feeling very disempowered. So what we do is we encourage people to organize. We encourage tenants to know that they have resources and point them in the right direction of those resources. And we empower them to know that they can, represent themselves or even do some of the eviction work or preparing for court when it comes to an eviction themselves. So if you want to learn a little bit more about that, I know Mary is going to talk a little bit more about right to counsel in her slides. But if you do know someone that is interested in learning a little bit more about right to counsel, you can reach out to me. My email will be provided at the end, and I can point you in the direction of people who will have resources to help you. Lastly, we are a fair housing enforcement agency, meaning if someone is in violation of the Fair Housing Act, we do have the right to go in and take whatever action is necessary once we investigate a discrimination complaint. That action can be as, simple as writing a cease or desist letter to a landlord who has a discriminatory ad running. Or it could be as complex as representing someone who was discriminated against in a case in court, right? It is a case-by-case basis. So we always tell people, if you feel like you've been discriminated against, give our intake line a call so that we're able to deduce the situation and see what can be done about it. So now our little history lesson on the Fair Housing Act. In order to make sure that everyone has equal access to housing, Congress passed the Fair Housing Act of 1968, which prohibits discrimination based on your membership in a protected class in all forms of housing transactions. Connecticut is actually doing a really good job with their state fair housing laws. They have protected vulnerable members of our communities by enacting additional statewide fair housing laws. And we are a model state when it comes to fair housing protections because we have a lot of protected classes. But I always like to highlight that the word pass is in bold. I am a schoolhouse rat kid, so when I think of laws being passed, I automatically think of the I'm Just a Bill on Capitol Hill song. Unfortunately, as simple as that song was, That wasn't the path that the Fair Housing Act of 1968 took. This was passed 7 days after King Jr., and the country was in a state of uproar. And President Johnson at the time was looking for a way to bring peace to the country. So he and his constituents went through the Rolodex of what Martin Luther King Jr. was working on and wanted to present to Congress. And the Fair Housing Act was one of those things. Now, President Johnson was, looking forward to passing the act, but a lot of members of Congress and a lot of individuals that, were just living at the time were very opposed to the Fair Housing Act of 1968 because it meant that communities that were traditionally segregated, that traditionally kept people of color and poor and migrant families out, would now have to integrate those communities due to this act. So there was a lot of back and forth and a lot of pushback with regards to the Fair Housing Act of 1968. But thankfully and luckily for us, it was passed, and now we have these wonderful protections for people who may face discrimination. So when we say protected class, another way that I like to phrase it is vulnerable pockets of people that are facing discrimination or are likely to face discrimination. So on a federal or countrywide level, it is a violation of the Fair Housing Act to discriminate against anyone based on these categories in any housing related transaction or housing transaction. It's a violation to discriminate based on people's race, color, national origin, sex, disability, religion, or familial status, which is the presence of children within a family. Connecticut has taken the step to add ancestry, marital status, age, sexual orientation, lawful source of income. So that is whether an individual is using a Section 8 voucher, SSI, SSDI to pay their rent, gender identity and expression, and veteran status to our state-specific list of protected classes. I always also like to highlight that disability was added in 1988 and veteran status was added in 2017. So that means that this is not a definitive list, right? This is not something that is just set in stone. This list can be expanded within the next 2 years, the next 5 years. It could look a lot different than it does now. But what we need people to do is to be able to identify discrimination and be able to report that discrimination so that if necessary, we will have the case law backing that we need a new protected class added to this list. Who must obey the fair housing laws? The Fair Housing Act applies to various people and entities involved in various stages of housing transactions. It is included, but not limited to, organizations offering rental assistance, including public housing, agencies that do housing counseling, including placement, sober houses, transitional housing, among many others, and housing providers with some limitations. There are some exemptions to the fair housing laws, federally and statewide. We always encourage people to not worry about what those exemptions are. If you feel like you've been discriminated against, give us a call because we'll be able to make that differentiation on whether there is an exemption. But even if it doesn't violate the Fair Housing Act, there are other laws that discrimination could violate. So we always encourage you to call us and report that to us, and you'll be able to have our contact information at the end of this presentation. When you call into our intake line, our intake specialist is going to ask you a lot of questions because they're going to try to uncover all of the details of the events that happened. What they're trying to do is to ask these or get answers to these 3 questions. Is the person covered? Meaning, is the person a member of a protected class? Is the property covered? Again, we mentioned that there are exemptions under the Fair Housing Act. So our legal staff and our intake specialists are able to see whether that property is exempt or not. Lastly, we want to uncover, is the behavior covered? Is this person being discriminatory, or is this person what I like to call an equal opportunity jerk? Are they just mean to everybody that calls in or mean to everybody that comes to view their unit, right? I'm going to give you a couple of examples of discriminatory behavior in a couple of slides, but these are the 3 questions that our intake specialist is trying to uncover when you call in. So they're going to ask you a bunch of questions to uncover all of these details. So I said discrimination maybe 20 million times within the past couple of minutes, but now we're going to take a step back to define what that means under the fair housing umbrella, right? So discrimination takes two forms. It is either differential treatment, which is treating people differently because of their membership in a protected class. So I'm going to jump back to our protected class list. What differential treatment usually looks like is I don't rent to people of your race. I'm not going to sell my property to people of your sexual orientation. Oh, I would love to help you, with this real estate deal or be a real estate broker. But unfortunately, I don't help people of your religion. Our firm doesn't represent people of your religion. Differential treatment is often something that is easily detected. It's kind of that gut feeling, like I feel like something is not right. Disparate impact, however, is a little bit more complicated to uncover. Disparate impact is a neutral rule that has a greater negative effect on members of a protected class. So going back to our protected class list here, I always like to highlight that, people who are just as impacted or may have criminal backgrounds are not represented explicitly on our protected class list, whether it is federal or state. And many times when I do this presentation for, people who are working in the reentry community, they'll highlight that. And I'll say, yes, that is true. But let's say, for example, a housing provider had a blanket policy or rule that said, no one with an arrest will be considered for this property, or no one with a conviction will be considered. That may not seem to violate the Fair Housing Act when you first look at it, but through the rule of disparate impact, a policy such as that, or a blanket policy such as that, will have a disparate impact or a greater negative effect on our race and color protected classes, because we know the rate that people of color are arrested and convicted are higher than every other race or color in the state of Connecticut and nationally. So through the rule of disparate impact, we're able to look at policies that may be put in place and see if they have a greater negative effect on members of a protected class, and thus rope individuals under the fair housing umbrella for protection that way. So here are a few ways to identify housing discrimination, and these are a few scenarios that we have had cases on. Sometimes when housing providers find out a detail about a potential tenant that doesn't really spark their liking, they will misrepresent the availability of housing. So for example, let's say I call in to a housing provider because I would like to view a unit. And the conversation seems to be going well until my daughter runs in the background screaming. And the housing provider might ask some leading questions. Hey, is that your daughter? Or hey, is that your son? Oh, wow, that's awesome. And get to the point where they say something to the effect of, I'm working with someone else to kind of market this property, and I think we may have accepted a deposit for it. But, keep checking my website, keep looking around. We post regularly. Now I'm a little bit deflated, but I continue my housing search, and days, weeks, even maybe months later, I'm still seeing that property that I called about, that the housing provider said they may have accepted a deposit. I'm seeing it pop up on wherever it is I'm doing my housing search. So that is a violation of the Fair Housing Act. We've seen cases where people flat out refuse to rent or sell to individuals because of their membership in a protected class. Discriminating in terms and conditions, we've seen that with our population that has disabilities, where, for example, an individual that is using a mobility aid, such as a wheelchair, went to look at a unit that had hardwood floors, and the housing provider said, well, if I rent this unit to you, you're going to have to pay an extra security deposit because I know that your wheelchair is going to mess up my floors. So a good rule of thumb when it comes to these policies, from housing providers, what happens for one has to happen for all across the board, unless this individual has a disability and is requesting a reasonable accommodation or a reasonable modification. You can't just charge someone an extra security deposit because they're using a wheelchair, or because they have a service or support animal, or because they're a person of color, or because they have children, if you're not going to do that across the board. We've seen discriminatory advertisement. You would think people would not be as bold as to put their biases in print, but we've seen terms such as able-body preferred, better for single professional. Flat out, people have said no Section 8 will be accepted at this property. Those are discriminatory advertisements. Uses of threats, intimidation, or coercion are all violations of the Fair Housing Act. There was an instance where an individual went to go view a unit and the housing provider said something to the effect of, well, if we rent this unit to you, we would prefer you use the back entry or the back exit as your main entrance and your main exit, because I don't want any questions about the type of people I'm renting my unit to. And it was followed by a threat of action. I'll call the police. I'll do A, B, or C if I find out that you're using that front door, right? Lastly, discrimination with a smile. It seems as if the housing provider is trying to do you a favor. It seems as if they're trying to help you. And you may take it as that, but upon further investigation, or if you speak to someone who works in fair housing, you'll see that there was some discrimination there. For example, let's say an individual, we're going to continue to go with the using the mobility device or the wheelchair example, goes to go look at a unit and everything seems to be going well. Until the housing provider says, well, I don't think you'll be comfortable in this unit because there are no medical facilities in this area. I don't know how you're going to get to and from your doctor's appointments, making the assumption that this individual needs to constantly access a medical facility. My friend is renting a townhouse the next 2 towns over. I think you'd just be more comfortable there. Or sometimes housing providers will say things of, I don't know if you fit the aesthetic of this neighborhood. I don't know if you'll be comfortable living here, right? May seem as if they're trying to be nice or help you out, but in reality, they're steering you. You should be able to live wherever you can afford to live, and it's not up to the housing provider or the landlord to to tell you what your level of comfort is going to be in that unit or in that neighborhood. So just these are some examples of how housing discrimination shows up in your searches for housing. So I gave Connecticut a huge pat on the back earlier. I was like, oh my goodness, guys, we're doing so great. Connecticut, you're doing amazing. Look at all of these protected classes, right? But now this is where I kind of take back some of that praise, because the United States and Connecticut remain highly segregated. We are actually one of the most segregated states in the country, with 67% of the population of color living in 8% of Connecticut's towns. People with disabilities and people who have housing vouchers experience discrimination at higher rates than every other protected classes, and are the bulk of the intakes that we get here at the Connecticut Fair Housing Center. But seeing those numbers on the screen, like, it's daunting, yes, but to bring more of a reality to that 67% and 8% of Connecticut's towns, this is what that looks like represented on a map, where the percent of non-white residents by census tract is represented by the color blue on the map. So we're doing a very good job at enacting the Fair Housing Act. Like, we know that there is a law that is there that protects people from being discriminated against in housing. We know that there are protections under the Fair Housing Act. But what we're, trailing behind in is enforcement of the Fair Housing Act. Because if the Fair Housing Act was truly enforced, there would be a lot more diversity across this map, and a lot more opportunities for non-white residents to live across the state of Connecticut. I always like to highlight the need for the Fair Housing Act. Our migration patterns in the Northeast specifically are developed with regards to population booms. We had one major population boom after World War I and another one after World War II. So logically, when you have an influx of people, you're going to need housing. But where you put that housing and who gets to live there is what truly shapes our communities. We do have a more at-length presentation that is 2 hours long that gets into 100 years of fair housing history. But of course, for the sake of time, I am going to condense that into about 4 to 5 minutes. So in that presentation, we talk about the Industrial Revolution in the early 1900s, where factories and factory work was what really developed our communities. Worker-built housing before and during the Industrial Revolution, however, often excluded non-white workers. So factories developed communities and then developed housing for factory workers. With the exclusion of non-white workers from being able to attain that housing, they were pushed further into the outskirts of town and further away from these resource-rich pockets that were created around these factories. So not only were they excluded from housing by they were also excluded by that, by not being able to live there, from being able to access, dependable health care, access education services, access groceries, right? So this kind of forced non-white workers to fend for themselves. Pictured is the Colt factory housing that was built in 1910. Now we're moving on to the 1920s and the 1930s, and the cry of the 1930s is the Great Depression. And the federal government is scrambling to protect the real estate that was being developed and that had already been developed from the Great Depression. So the federal government created two government agencies, the FHA, or the Federal Housing Administration, and the HOLC, or the Homeowners Loan Corporation, which assessed the risk of lending and created redlining maps. And these maps were color coded by race, where, predominantly the Caucasian population were seen in the green and blue areas of the map. These green and blue areas were also seen as prime and ideal areas for real estate investment, and also prime areas for foreclosure remediation or recovery funds if the Great Depression had tanked the real estate that they were trying to build. Adversely, the yellow and red areas where the population of color and poor and migrant families were focused were seen as hazardous and not fit for habitation or not fit for real estate development. Also not fit to receive, primary financial funds or recovery funds if, foreclosure had threatened to decimate their neighborhoods. The effects of redlining, we could still see them today, where in historically redlined areas, you see lower home ownership rates. You'll see a lower credit score rates in those areas, and a host of other issues. Moving into the 1940s and the 1950s, post-World War II, unfortunately, war is really good for the economy. So billions of dollars were being poured into the federal government. And what the federal government wanted to do with that money was develop the suburbs, and also develop loan products that were geared towards new housing development in the suburbs. The way those loans were written, unfortunately, excluded non-white families from home ownership. So this is where a real big gap in generational wealth happened between families of color and white families. Simultaneously, while that was happening, to cater to greater dependency on the automobile, highway development began and urban renewal followed when highway funds ran out. And these two initiatives decimated non-white urban neighborhoods. And in the 1960s came the Fair Housing Act, which was basically a response for decades of calling for equity in housing and calling for people to be represented in housing and being able to have a fair shot of not being discriminated when trying to find safe, stable housing close to their work and close to resource-rich pockets. So I say all that to say this is why we were founded in 1994, and this is why we continue the work that we do today. If you or a family member or someone that you may know, friend, has experienced housing discrimination, you are welcome to call our intake line. We do have English and Spanish translations on our main intake line, or you could call our toll-free line where translators are available. You could also report that discrimination online by visiting our website. There is a portal where you can type up a housing discrimination complaint. We have a bunch of resources on our website, from COVID-19 resources to a reasonable accommodation letter generator for our population that has disabilities that is looking to, request a reasonable accommodation or modification from their housing provider. And we also have a moving forward guide for renters in the state of Connecticut and homeowners in the state of Connecticut, or people who are desirous of buying a home. So these resources and this resource slide will be available to you so that you're able to access it at your leisure. And I will also provide my email so that you're able to contact me if you are looking to set up a training. I am not the intake line, so your best bet in reporting housing discrimination is to use the resources that are here on the screen. But if you're looking to have a community event where you feel like fair housing education will be impactful, or you think of an agency or something that you would like to have me speak at, you can email me at T as in Tango, RAY at CT fairhousing.org. And I will drop that into the chat box for our individuals that are joining virtually. With that being said, I'm going to stop my share. Thank you guys so much for your time, and I'm going to pass it over to Mary.
It might help if I unmuted. So let me see now if I can get to my PowerPoint. Oops. I may have to put this in. Okay. You don't think I'm sharing this, so. Okay, so am I actually sharing this now? Can people see it?
Yep, we can see your screen.
Okay, and it says Connecticut Legal Services, right? Let me put on the slideshow. Okay, so what I'm going to do is go through some, basic information that it would be helpful to know about evictions, some resources that folks can go to if they want more information or assistance in learning how to deal with evictions. And I'm going to also explain somewhat the Right to Counsel program. So our program, which I mentioned before, is Connecticut Legal Services. We provide access to justice and to critical legal rights problems for low-income persons. We do direct representation. We also do some systemic advocacy. In other words, looking at the picture as a whole and trying to fix it at a higher level than just one individual. We give advice, and then we collaborate and do some sort of education such as this. But our principal role is to assist tenants who are involved in legal matters. So here's my information. I manage our program's housing unit. I actually work in Waterbury, and there's my email information if you want to get in touch with me. It's mconklin@ctlegal.org. So again, we're a nonprofit law firm providing free legal aid to low-income individuals. Connecticut Legal Services is the largest of the legal aid agencies in Connecticut. We serve pretty much the whole state except for the towns around Hartford and around New Haven. We have offices in London, Willimantic, New Britain, Bridgeport, Stamford, and Waterbury. So as I mentioned, our program would be the one that would cover tenants who have need legal assistance in the Stamford area. At this precise moment in time, we have 2 attorneys. One is relatively new. We are not yet open for right to counsel in Stamford, but I'm anticipating that happening probably in the next couple of weeks, just as soon as I kind of get Matthew trained. And as I'll explain later with the Right to Counsel what the Right to Counsel program is and how we've set up trying to put it into place. Oops. Okay, and again, we collaborate with other legal service type organizations. Here's some really helpful resources. First is this, oops, I should spell it right, oops, I messed that up. I have to correct the spelling there, but it's www.ctlawhelp.org. That is a website that is, I believe, a lot of the legal service programs in the state cooperate with. It has pamphlets on numerous issues that lower income people would find. It has videos on how to represent yourself in court, or how to, what to expect if you get into court. I mean, we can if we have time, and I'm not sure we will at the end. I could just show you that website, but that's a really useful website. Our legal services, Connecticut Legal Service website is ctlegal.org, which is probably going to send you to ctlaw.help. There's another organization in Connecticut called Statewide Legal Services, and that's basically an advice and referral organization. They don't really represent tenants. Most of the time, they may do a few cases a year, but primarily that is the agency that we refer tenants to when we get calls at local offices. They then do the screening to make sure people are eligible, get some basic information, and then send the referrals to us to actually meet with the tenants and to provide direct assistance. So it's a statewide legal services is going to be the main contact for tenants seeking assistance, both in the non-RTC programs and for RTC, again, right to counsel. The judicial website has a lot of information. There's forms for housing for both landlords and tenants. There's booklets, one for landlords, one for tenants. They have frequently asked questions. You can go online, and if you know that an eviction has been filed, if you know the name of the party, whether the landlord or the tenant or the address, you can look up what's going on with that case and pretty much see everything that's been filed on it. There is the Section 8 voucher program. It's a subsidized housing program where HUD funds through housing authorities the vouchers that can be taken to private landlords to get lower income rents, because that is so valuable. And in fact, the main problem we have here in Connecticut is we have a lack of affordable housing. The Section 8 program has long wait lists. And when an agency like, say, the Waterbury Housing Authority has used up the numbers on its wait list, they will open the wait list again. So you can register at 211 to receive notice whenever a housing authority is opening up applications to their wait lists. So that's kind of a critical number if you're involved in trying to help people find housing. And then this last one is probably more so important for people who are actually representing tenants. It's the National Housing Preservation Database, and it lists pretty much all affordable housing in the country. And in legal services, we use it because there are kind of hooks that have to be in, say if a complaint is filed, there are certain requirements that have to be in their notices based on what kind of subsidized housing it is. So we use this database a lot, but for the average person off the street, you probably aren't going to use it. I mentioned right to counsel. The right to counsel program just got off the grounds this January 31st. And right now it's being phased in by zip code. So this is the information where a tenant could call to find out if they are in a zip code that's being covered. Or evictionhelpct.org gives more information about the program generally. Okay, so here's what we're going to try to cover today. Right to counsel. In terms of evictions, who's protected by eviction laws? What are the reasons and defenses that can be raised in eviction matters? And then what are the steps in the eviction process? So first, right to counsel. So the basis in part for this program is that less than 10% of tenants have a lawyer when representing them in eviction proceedings, while over 80% of landlords are represented. Last legislative session, 2021, the state appropriated money to create this right to counsel program. The amount of money they gave basically, I think, extends through the end of 2024. We're trying at this point to phase it in. It will allow us to represent tenants who are either in the eviction process or are at risk of losing a housing subsidy. So say if a housing authority wants to terminate a program, we can also help those folks. The money that was appropriated was, as I say, was quite good. It was almost, I think, 10 million a year for 2 years, so 20 million altogether. The problem we've been having, strangely enough, is that we can't hire enough attorneys there. We have we've been advertising and trying to beat the bushes for attorneys, and we're just not getting that many right now. And I'm not quite sure why that is. So it's been a little bit slow. The representation is provided by 4 legal service agencies right now. It's managed by a state organization called the Connecticut Connecticut Foundation. But the programs that actually are doing the work are Connecticut Legal Services, the Connecticut Veterans Legal Center, Greater Hartford Legal Aid, and New Haven Legal Assistance. As I said, the programs started to be phased in January 31st. Now, right now, who's eligible based on location, which is the criteria that we've started with. So if a person is a veteran who's being evicted, they can, their ability to access this program is statewide right now. And then the Veterans Law Center actually takes on those cases. Otherwise, the other 3 legal service programs have identified zip codes based on an implementation plan that Connecticut Bar Foundation sort of set up. And as you can see down below, we've listed the current zip codes that are being covered. Connecticut Legal Services, because it has to cover the whole state, has had some really hard choices to make in terms of, can we cover, more than one zip code with the staff that we either have or we can hire. And as I say, hopefully that gets better as we're able to hire more people. But for now, we are only able to cover right to counsel cases in Bridgeport through 1 zip code. As I say, we're not doing Stamford yet, but that should come online soon. And at least at this point in time, I'm considering opening the largest zip code in Stamford, which I can't remember off the top of my head, but maybe 902. But Stamford will soon be online for this. And we will continue to increase the program as we hire staff. We're now looking at a 5-year implementation plan to try to set it out to actually have the state be fully covered. If tenants want assistance by the end of 5 years. So that tenants have an income level. The income level is 80% of the state median income, which is quite high, much higher than what would have been normal legal services financial guidelines. So a family of 4, and this is based on 2021 figures, and I'm not sure that the Bar Foundation has actually increased to 2022 levels, which I've looked up. 2022 levels are much higher. I mean, in each category, they're close to $8,000 to $10,000 more. So I need to check that and see if they've actually changed to the 2022 numbers. But even at this level, these are, it's a program that's available to, I'm going to guess, probably the majority of the people who are having evictions filed against them. I think that the factor that was used in calculating how many attorneys was needed was that approximately 5% would be over income. So this program does cover a large number of people. Go back one. So how does a tenant know that they might be covered by this program? First, the statute that passed the act last year required that a notice be given to all tenants of the availability of this program by providing a notice. The notice is on the court website. It has to be that notice. And it has to be given to tenants at 2 stages of the eviction. The first stage, which is when people get a notice to quit, and then the second stage when they actually get the court complaint. So by the time it gets to court, the tenant should have gotten two notices telling them they have this right. Now this is what it looks like. And it's only half because I could only screenshot half of it. But it's basically tells tenants that if they're facing the loss of their home or housing subsidy, they can contact the telephone number that's there, the hotline number 1-800-559-1565, or they can visit the website evictionhelpct.org. And as I say, this notice is in both English and Spanish, and the Spanish version is on the section below. It's all on one page. So if a person wants to know if they're in a region that's presently offering RTC, they can just contact those numbers or scan the QR code if you know how to do that, and get to this program. We probably are now seeing more cases coming in at the earliest notice stage than in the past. So the notice is working somewhat, but there's still a lot of people who actually don't respond to eviction complaints when they're filed. Okay, and again, those are the numbers. So at this point, that's where the Right to Counsel program is. When we mentioned earlier, if people are going to look at this, these PowerPoints at some point in the future, you'd want to double check those zip codes, because those should be increasing the number of areas covered with some degree of frequency. Okay, so I'm just going to go through a pretty quick presentation on just basic eviction law, who's covered, what reasons can be used to evict, and then basic steps in the eviction process. So I always start with these myths. Do tenants get 3 months to move? Can tenants be evicted when they're ill? Can a landlord evict just because the lease is over? And can tenants be evicted in winter or bad weather? And the answer to all of those is yes. No, wait, I should say that the answer is to the negative on the tenant side. So do tenants get 3 months to move? Not routinely. The only time they may get that is if they can deposit all the rent that they owe, and then they can ask for 3 more months if they've lost their case. Can they be evicted when they're ill? Yes. There may be some limited ability to ask the court to come back in the court and ask for an extension of time, but that's not an absolute. Can a landlord evict just because the lease is over? Yes. In Connecticut, at the end of any lease term, a landlord can bring an eviction. They don't have to have a reason in most cases. Other than obviously going back to the initial discussion, it can't be discriminatory. Can tenants be evicted in winter or bad weather? Yes. Have to make sure that people understand that only a judge can enter an order to evict somebody from the property. There are very few exceptions to this rule. Even squatters have to be evicted. And a landlord can't just come and lock you out. That's illegal. It's actually criminal. If people are interested again in knowing whether there's a case that's been filed, maybe that would be really helpful if you're trying to find out whether there's actually been an order from a court that somebody is evictable. Then they can check at the court website, just www.jud.ct.gov, and there's a case lookup feature. Who's protected by eviction laws? And I said it's almost everybody. The exceptions being if somebody lives in a hotel, motel, or similar occupancy situation and has been there for less than 30 days, and it's not a primary residence, then the eviction laws don't protect. However, if that is in fact their primary residence, even though they've only been there for less than 30 days, the hotel or motel has to use eviction as a way to get them out. If they've actually lived there for over 90 days, even if it wasn't their primary residence, then again, the hotel or motel would have to bring an eviction. And then people who live in residences where housing is incidental to some other kind of service, such as medical, geriatric, educational, counseling, or religious, then they don't have to be evicted. They're normally in those situations, particularly the ones that have some medical component to them, say like a nursing home, there's a separate kind of procedure that is used for when the provider wants to remove an occupant. It's a less protective kind of procedure, but there is one there. What are the reasons? Now, Connecticut has a statute that defines what reasons are permissible for eviction. And if the landlord who's attempting to evict uses any different reason, it's not good, and the case could be dismissed because they need to fit within the statutory reasons. And they basically are these: non-payment of rent, a material breach of lease, lapse of time, which we talked about, which just means the lease is over, nuisance, which basically means you're disturbing a neighbor or in some way interfering with their rights, serious nuisance, which has 4 definitions and is, as you would guess, probably the most harmful to either the landlord or the tenant or the other tenants. And then there's these 2 kind of strange grounds: that people had a right or privilege to be there, but it's been terminated, or they never had a right or privilege to be there. And that's kind of the squatter situation, or somebody who's moved in, say, and it moved in with somebody else who has a lease and they move out. But those 2 reasons are not as critical. I would say they were rarely used, but since COVID, we've been seeing more and more of them because landlords were trying to find ways to get people out and around the moratoriums that were in place that prevented eviction at that point for non-payment of rent or lapse of time or nuisance. So, okay, so the reason for eviction that we see most often is obviously non-payment. There are certain defenses that can be raised in a non-payment case. One can be that the rent was offered before the service of the notice to quit, which is the first document that needs to be served on a tenant before an eviction. If rent has been offered before the service of the notice to quit, the case can be dismissed, or you would win if it went to trial. If a landlord has allowed rent to be mailed, they bear the risk of a lost check as long as the tenant can prove it was mailed on time. Landlords have to give receipts in Connecticut if a tenant pays by cash, but if a tenant pays by money order or some other form that has a receipt that comes with it, then the landlord doesn't have to do that. Now, I don't think I talked too much about leases in this presentation, but it's important to know that most people have leases. I hear all the time that I don't have a lease, but in most of those cases, people have what they call an oral monthly lease. In other words, it was an agreement that was made verbally between the landlord and tenant, and the tenant pays the rent for the month. That creates an oral lease. And under Connecticut law, you're protected you have all those protections that a tenant with a lease would have. It doesn't really make a difference if it's written or oral. There is a lease. And in most situations whether oral or written, the leases normally, the payment dates are normally the first of the month. And there's a Connecticut statute that says you have a 9-day grace period. So a notice to quit or an eviction in a sense can't be started until the 11th day. So that's the protection that tenants have. It gives them time to pay. And as I had indicated in the top bullet point, technically tenants get the right to pay until, if they pay before the service of the notice to quit, which could be after the 11th, eviction would still be stopped. I mean, other defenses are serious substandard conditions, and they have to be serious, or the court won't consider them as grounds for non-payment. They may be grounds to bring a separate action called a payment in a court action, where you ask the court to monitor the repairs. But if a tenant holds rent because they don't like the conditions of the apartment and the court doesn't feel that they're serious enough, and in some courts, the judge almost always requires that you have complained to somebody, that's not going to be a good grounds to defeat the non-payment. I mean, one other defense could be, we didn't have a rental agreement. And that's in certain limited circumstances. Normally where there was a rental agreement and say the landlord, the example that we use the most is the landlord says he wants a rent increase and you don't, and the tenant doesn't agree to the rent increase, since there's no longer, we call a meeting of the minds of the parties as to what the basic terms of the agreement are, there's no lease. We advise tenants to offer the old rent, but if the landlord tries to evict there because using non-payment as a grounds, it's wrong because there was no lease. That's why, as I mentioned, those, whoops, go back again, that the condition, the reason it says you had a rental agreement, but the rental agreement is terminated is the actual reason that should be used in those cases. And it makes a difference because at the end of the process, the tenants can ask for more time. And the difference between a non-payment case and a whatever right or privilege you had is terminated case is the ability to ask for 3 months and pay what you owe up front or 6 months. So it's important to make that distinction. There are also equitable defenses, which I think of as fairness. They're particularly helpful where people have subsidized housing because the loss of the subsidized housing is so great, where if a tenant can make up what they owe, that the damage to the subsidized landlord is not, and the courts will find that tenants in that situation should not be evicted. We also use this at times in situations where, say, somebody does have a serious health condition and it occurred, say, after the court ordered them even to be out. We may use this as a reason if the person really is not available to ask for a delay in the move out. Then I mentioned there's material breach of lease or tenant responsibility laws. And those again are things such as disturbing the neighbors. A lot of subsidized leases say you can't have unauthorized persons living in the place in your apartment. That could be a grounds. You know, having a dog could be a grounds if you don't have a reason to have it for health-related reasons. So it could be any number of things that's in the lease. And in those cases, in terms of defending, obviously you can always say dispute that the misconduct occurred, but in this particular area, the landlord has to give a notice prior to the notice to quit, which gives the tenant time to cure or correct the problem. So if that's not done, then that's also grounds for the case to be thrown out. In some circumstances, the alleged misconduct may relate to a tenant's disability. And so the tenant can request a reasonable accommodation as part of any kind of an agreement with the court between the parties. So trying to think of, we had at one point had a client who, an older client who was starting fires with his stove when he tried to cook. So we worked something out where he was going to use his microwave oven so he couldn't cause fires. Anything you can think of that relates to the disability and which will help the tenant to avoid whatever problems are being perceived based on that disability. You can try to get a reasonable accommodation. You will need probably some kind of medical documentation or request, but we often use that in material breach cases.
Thank you, Mary. So just in the interest of time, I'm just going to open it up to
Okay.
in the chat. So if you have a question in the chat, just jot it down really quickly in the chat. And do you have any? And we have one question for the person